Welcome to the deep dive. This one's really geared towards listeners familiar with the great discussions over on the Top-Notch Injury Attorneys podcast, especially folks here in Jacksonville.
That's right.
Today, we're digging deep into something that, well, it affects a lot of people, unfortunately, handling the legal side of things after a car accident in Florida.
Yep. Think of this as us doing the homework for you.
Mhm.
We've gone through, a stack of resources articles from Florida law firms on negotiating settlements, what those average settlement numbers really mean. Spoiler.
Yeah.
Very, very wildly.
Always good to know.
Uh-huh. Also, what happens if the insurance company doesn't seem to be playing fair bad faith claims? Plus, the kind of questions you should ask a lawyer, immediate steps after a crash, those crucial deadlines, statutes of limitations.
Right.
And, why you might actually need an attorney. We even looked at a Reddit thread about when people felt a lawyer was really worth it.
Okay, so our mission today is pretty straightforward. Give you the essential legal info for Florida car accidents. We want you to feel, empowered, informed if this happens.
Exactly. Ready to make smart choices.
All right, let's jump in. Picture this. The accident just happened in Jax. Chaos. What are the absolute first things someone needs to do, legally speaking?
Okay, so right after, those first few moments are critical. Pretty much all our sources agree on a few immediate must-dos. If anyone's hurt, or even if the damage just looks like it could be over $500.
Which can happen fast.
Oh, yeah. Call 911, get the police there, that police report.
Yeah.
It's often legally required here in Florida for those situations, and it becomes like the foundation for everything later.
Get it official, makes sense. What about injuries? Maybe you feel okay right then.
That's such a key point.
Yeah.
Get checked out by a doctor and do it quickly. Adrenaline is powerful stuff. It can hide injuries. Plus, documenting all your medical treatment right away is vital. Any delays? Insurance companies love to point to those later and argue, well, maybe that injury wasn't really from this accident. Don't give them that opening.
So, immediate documentation is king. Beyond medical, what about the scene itself?
Right. If you're physically able to, use your phone. Take pictures. Take videos. Get everything. Damage to all the cars, different angles.
Okay.
Any visible injuries? Sure. But also the bigger picture, traffic lights, signs, road conditions, skid marks, debris. This stuff can be gold later when figuring out who was at fault.
You're basically starting your own evidence file right there.
You got it. And while you're doing that, talk to people. Get names, phone numbers, insurance info from the other driver or drivers. And crucially, witnesses. If anyone saw what happened, get their contact info too. Independent witnesses can be incredibly persuasive.
Okay, so gathering info. Now, the tricky part often starts dealing with insurance. What's the big rule right after the crash?
Two big don'ts really stand out. First, don't admit fault. Even if you think you might share some blame, just stick to the facts when talking to police or others involved. Let the investigation figure it out.
Okay. No, I'm so sorry. It was my fault.
Exactly. And second, absolutely do not sign anything from an insurance company, especially the other drivers, without talking to an attorney first. They might slide a release form in front of you that seems simple, but it could sign away your rights for good.
Wow. So even if they sound friendly and helpful on that first call.
Be very, very wary. Now, you do need to report the accident to your own insurance company. Remember, Florida's a no-fault state. Your PIP coverage, personal injury protection, is your first line for medical bills and lost wages, up to $10,000 no matter who caused the accident.
Right, that's the no-fault part.
Correct. But even when talking to your own insurer, be careful what you say. Stick to the basic facts. Those recorded statements can sometimes be used in ways you don't expect later on.
Okay, that's a lot to handle right at the start. So, assuming we've managed the immediate chaos, been careful with initial calls, what's the next major phase?
Well, that usually leads into settlement negotiations, especially if your damages go beyond what your PIP covers. And the absolute first step there is figuring out what your claim is actually worth.
How do you even start doing that?
You need to tally up everything. We're talking past medical bills, sure, but also what future medical care might cost. Lost wages, what you've already missed, and potentially what you will miss if you can't work the same way.
Okay.
Damage to your car, obviously. And then there's the less tangible stuff. Pain and suffering, the impact on your life. That's a real part of the damages.
That pain and suffering part, it sounds so subjective. How is that calculated?
It is subjective, which makes it complex, but it's no less real or compensable.
Yeah.
So once you have a handle on all these damages, the hard numbers and the softer impacts you need to figure out a settlement range you'd be okay with. But here's a pro tip from basically all our sources. Don't tell the insurance adjuster what that bottom line number is.
Keep it to yourself.
Exactly. You start by asking for the full, fair value of all your damages. Let them make the first real offer.
And what should people expect that first offer to look like? Probably not great.
Uh, yeah, you should probably brace yourself for a lowball offer. It's a standard negotiation tactic. They're testing the waters, seeing if you'll take a quick, cheap payout, maybe because you need the money or just want it over with.
Right. Don't take it personally, I guess.
Try not to. It's just business for them. It's the start of the negotiation, not the end.
So how do you push back effectively? How do you actually negotiate with this adjuster?
It requires being prepared. First, have all your evidence organized. That itemized list of damages we talked about. Back it up with proof. Medical bills, repair quotes, letters from your employer about lost wages.
Got it. Documentation again.
Always. Then, try to anticipate what arguments the adjuster might make and have your responses ready. Stay calm, stay professional, even if you're frustrated. You negotiate best from a position of knowing your case's strengths.
Be firm but polite.
Exactly. Be open to some compromise, potentially, but stand firm on the core value. And critically, get everything in writing, every offer, every counteroffer, every agreement. Paper trails are essential.
And that first offer?
Almost universally, the advice is,
Yeah.
don't take the first offer. Resist the urge.
It feels like a strategic game. How do you decide when an offer is good enough to accept?
That's a judgment call, weighing several things. How fast did they make the offer? Sometimes a quick offer on a serious injury is a red flag they know it's worth more. Think about what you might realistically get if you went to court versus this settlement amount.
Factoring in the risks of court.
Precisely. Going to court costs money, takes time, and there's no guarantee you'll win or get more than the settlement offer. Juries are unpredictable. So you weigh the certainty of the settlement against the potential upside and downside of a trial.
A bird in the hand, potentially.
Sometimes. Also, keep good notes during negotiations. What points seem strong? What documents you have ready? Patience is really important here. And don't ever assume it will settle. Keep gathering evidence like you're going to trial, just in case.
Because they might just drag their feet.
Insurance companies are sometimes known to use delay tactics, yeah. Hoping you'll get worn down or that evidence will disappear. If things seem to be stalling for no good reason, that's a sign you might need help.
This definitely shows it's more complicated than just sending a bill. Okay, let's talk numbers. What is a typical car accident settlement worth here in Florida? Is there an average?
The million-dollar question. Sometimes literally. The honest answer is it varies massively. Case to case, it's different. Our sources all stress this. How bad was the crash? How much property damage? How severe are the injuries? And, frankly, how good is your lawyer? All these things matter.
So comparing your situation to someone else's isn't really helpful.
Not really, no. You do see some firms mentioning averages they've obtained. Maybe you see numbers like $20,000, $36,000 thrown around. One firm we looked at, Waring Law, mentioned their average was closer to $50,000.
Okay.
But please, everyone listening, understand these are just averages based on past results. They're absolutely not a guarantee for your specific case. Yours could be much higher or much lower.
And these are mostly settlements, right? Not necessarily what happens after a full trial.
Generally, yes. Settling and going to court are different paths. When figuring out a case's value, insurers and lawyers look at objective factors. Medical bills, past and future, lost wages, past and future, any hit to your future earning ability, other out-of-pocket costs.
The hard numbers.
Right. Then there are the subjective factors. How bad are the injuries, really? How much have they affected your life, your relationships, that's loss of consortium, the actual pain and suffering, which, importantly in Florida, often requires proving a permanent injury to get significant compensation for.
A permanent injury threshold, that's key in Florida.
Very key. They also look at how severe the collision itself was, the other driver's record, any visible scarring. Again, documenting your injuries thoroughly through medical treatment is crucial to proving these things.
And insurance limits play a big role too, I imagine.
Huge role. What are the policy limits for the driver who hit you? What's your own coverage? We mentioned PIP pays up to $10 initially. If your damages are way more than the at-fault driver's coverage, hopefully you have underinsured motorist UIM coverage on your own policy.
Something everyone should check on their policy.
Absolutely. And just as a side note, commercial vehicles, like big trucks, usually have to carry much higher insurance limits in Florida.
Good to know. Okay, this brings us to a really practical question. When should someone stop trying to handle this themselves and actually call an attorney, like one of the folks from the top-notch Injury Attorneys Network here in Jax?
The sources give pretty clear signals. One big one is if talks just stall out. You send your demand, you follow up in dry crickets. Or the adjuster just won't budge from an unreasonable offer. That's usually a sign you need professional backup.
Makes sense if you've hit a brick wall.
Definitely. But honestly, there are benefits to calling earlier. A good attorney takes over all that stressful communication and paperwork with the insurance companies, with your employer for wage loss info. They can help guide your medical care to ensure it's properly documented for the claim.
Taking that burden off your shoulders.
Exactly. And they know how to negotiate. They understand the tactics adjusters use, they know what similar cases are worth, and they can build leverage. Their whole job is protecting your rights and aiming for a fair outcome.
What about the cost? People worry, I just had an accident, I can't afford a lawyer.
That's a common concern. But most reputable personal injury lawyers in Florida work on what's called a contingency fee basis, meaning you don't pay them anything up front. They only get paid if they win your case, either through a settlement or a verdict. Their fee is typically a percentage of what they recover for you.
So they have skin in the game too.
Right. Their incentive is aligned with yours. Get the best possible result.
Are there specific situations where having that legal expertise is almost essential?
Absolutely. If liability is disputed, if the other driver is blaming you, proving fault can get complicated fast. Attorneys know how to investigate, find evidence, interview witnesses, sometimes even hire accident reconstruction experts.
Things the average person just wouldn't know how to do.
Exactly. You should always ask a potential lawyer about their track record with cases like yours. They can also guide you on what to say, and more importantly, what not to say to insurance companies. People sometimes sink their own cases without realizing it.
That Reddit discussion you mentioned, did it touch on this?
It did. A lot of people commented that a lawyer felt worth it, especially when injuries were serious, or the case seemed complicated, or, frankly, if they just felt overwhelmed. Someone also mentioned lawyers can sometimes negotiate down medical bills or license at the end, meaning more of the settlement actually ends up in your pocket.
That's a really practical benefit. Okay, shifting gears slightly to something more serious. What if you suspect the insurance company isn't just being tough, but actually dishonest or unfair?
Yeah, that's when we get into the territory of bad faith insurance claims. Essentially, bad faith means your insurer isn't holding up their end of the bargain, their legal and contractual duties. They're acting dishonestly or unfairly, not in your best interest as their policyholder.
What kind of actions might signal bad faith?
Well, there are several red flags. Things like deliberately misrepresenting what your policy covers or the facts of the accident, unreasonable delays in paying a claim they clearly owe, failing to tell you they need certain information.
Stonewalling, basically.
Sort of, yeah. Or failing to communicate important updates, not investigating your claim properly or promptly, outright refusing to pay a valid claim without a good reason, or denying it without even really looking into it.
Sounds incredibly frustrating and potentially damaging if you need that money.
It is. To actually prove a bad faith claim, you generally need to show two things. One, that the insurer should have approved or paid your claim if they had acted fairly and honestly, and two, that you suffered harm because of their bad faith actions, harm beyond the original claim amount.
So you have to show their unreasonable behavior caused you further damage.
Correct. It often involves showing that any reasonable insurer would have handled it differently.
If someone suspects bad faith here in Florida, what's the procedure?
First step, always. Talk to an attorney experienced in Florida bad faith insurance law. This is complex stuff. If they agree you might have a case, Florida law requires you send a formal written notice to the insurance company. It's called a civil remedy notice. This notice spells out the alleged bad faith actions. The insurer then gets a 60-day window to cure the problem, basically. Fix it, pay the claim, resolve the issue.
They get a chance to make it right.
They do. If they don't fix it within those 60 days, then you can move forward with filing a bad faith lawsuit against them.
And if that lawsuit is successful, what kind of damages can someone recover? Is it just the original claim amount?
Potentially much more.
Yeah.
You could recover the original claim value, obviously, but also court costs, your attorney's fees for the bad faith case itself, any other financial losses you suffered because of their delay or denial, and sometimes damages for emotional distress if their conduct was particularly bad.
Really holds their feet to the fire. Okay, one last critical area, deadlines. The statute of limitations.
Absolutely vital. Cannot stress this enough. Florida has strict time limits for filing lawsuits after car accidents. For most personal injury claims, car, truck, motorcycle accidents, you generally have 4 years from the date of the accident to file a lawsuit.
4 years? That sounds like a decent amount of time, but...
But it can fly by. And importantly, there's a major exception. If tragically someone dies as a result of the accident, the lawsuit is for wrongful death. For those cases, the statute of limitations is much shorter, only 2 years from the date of the person's death.
2 years for wrongful death? That's a huge difference. What's the big takeaway and message here?
Don't wait. Seriously. Even though you have 4 years for injuries, the sooner you talk to a lawyer, the better. Evidence disappears.
Yeah.
Witness memories fade. Waiting makes it harder for your attorney to build the strongest possible case.
Makes investigating tougher.
Much tougher. And once that deadline, 4 years for injury, 2 for wrongful death passes, your right to sue is gone. Forever. Doesn't matter how strong your case was.
So time is truly of the essence when considering legal action after a crash in Jacksonville. Wow, this has been incredibly informative, really drilling down into the legal side, especially relevant for the top-notch injury attorneys audience.
Yeah, it's clear there's a lot involved, from those first moments right through potentially complex negotiations or even litigation.
Absolutely. Being informed about your rights, understanding the Florida-specific rules we talked about, PIP, permanent injury thresholds, statutes of limitations, it's all crucial for protecting yourself.
It really is. Knowledge is power in these situations.
And for our listeners here in the Jacksonville area, getting advice from experienced local injury attorneys early on seems like a really smart move to make sure those rights are protected and you pursue fair compensation.
Couldn't agree more. Local expertise matters. They know the courts, the adjusters, the specific state laws inside and out.
So thinking about everything we've covered today from the scene through negotiations, potential bad faith, all those rules, what specific part of Florida car accident law or that whole claims process do you feel maybe needs a closer look from your perspective, or perhaps warrants asking a legal professional about directly? Something to think about. Thanks for joining us for this deep dive.